Attorneys doing business, Rule 5.4 through 5.7. We have just reviewed the rules that address attorney advertising and solicitation. Now we will turn to the rules that deal with other business strategies a lawyer may wish to employ. Rule 5.4, Professional Independence of a Lawyer. This rule expresses the traditional limitations on lawyers sharing fees or having a partnership with non-lawyers. The express purpose of these limitations is to protect the attorney's professional independence of judgment. Rule 5.4a provides that an attorney may not share legal fees with a non-lawyer. There are a few narrow exceptions. If one of the partners in the firm has died, the partnership agreement may have provided that the firm pay fees to his estate over some limited period of time, and that is okay. If an attorney has died, disappeared, or become disabled, the attorney who purchases his practice may likewise pay fees to the estate as agreed in the purchase. The more typical exception is that a law firm may establish a compensation or retirement plan that is based on profit sharing and includes non-lawyer employees in the plan. Finally, if an attorney is working in conjunction with a nonprofit, for example, the ACLU, attorney's fees that are awarded in the case may be shared with the cooperating nonprofit. Rule 5.4b establishes that an attorney may not form a partnership with a non-lawyer if any of the activities of the partnership consist in the practice of law. As we've discussed, Rule 1.8f permits an attorney to be paid by someone other than the client if that person does not interfere in the attorney-client relation and the client gives informed consent. Here, Rule 5.4c similarly provides that the attorney must not permit the person paying the fees or referring the case to direct or regulate the attorney's professional judgment. Just as an attorney cannot form a partnership with a non-lawyer, a lawyer and non-lawyer likewise cannot form a corporation that practices law. Rule 5.4d provides that an attorney must not practice in a professional corporation or association established to practice law for a profit if a non-lawyer owns any interest in the corporation. The only exception is if a partner has died and his estate holds an interest for a limited period of time. Nor can a non-lawyer serve as a corporate director or officer in such a corporation or association. Nor can a non-lawyer have any right to direct or control the professional judgment of the attorney. Note that this rule does not prohibit non-lawyers from serving as officers or directors in non-profit organizations that practice law, such as legal services programs or a union-based prepaid legal service plan. This rule, prohibiting non-lawyers from investing in for-profit law firms, is not without its critics. Some argue that it is protectionist of established law firms. It does not permit outside investment in startup firms that might provide more cost-effective services. An early version of the model rules would have permitted non-lawyer ownership or investment in law practices with certain requirements for lawyer independence of judgment, as with prepaid legal plans. But when the bar realized that this would have permitted Sears, or today Walmart, to open a law office alongside its pharmacy, that killed the draft. Today, however, other nations, such as Australia and Great Britain, permit such outside investment. Rule 5.5, Unauthorized Practice of Law and Multi-Jurisdictional Practice. As we discussed, attorneys are admitted to practice in individual states by separate state bars and under the authority of separate state Supreme Courts. However, legal problems often do not respect state boundaries. Clients with national and international businesses retain law firms and want their firms to be able to answer their legal questions for that national or international business. Similarly, international corporate clients employ in-house counsel and may relocate in-house counsel to states where the corporate headquarters exist. How do the rules deal with these complexities? Rule 5.5 has been updated fairly recently to deal with some of these challenges. Rule 5.5a establishes that an attorney must not practice in a jurisdiction in violation of the regulations of that jurisdiction, and must not assist another to do so. The attorney may be admitted to practice in a state on a regular basis, or she may be able, by court rule or order or by law, to practice on a limited basis in another state where she is not a regular member of the bar. If an attorney is not admitted in our jurisdiction, he must not establish an office or other regular presence in our jurisdiction, and he must not hold himself out to the public as able to practice law here. If an attorney is admitted in another jurisdiction in the USA, she may provide legal services in our jurisdiction on a temporary basis under the circumstances identified in 5.5c. Comment 5 notes that these circumstances do not create an unreasonable risk to the interest of the attorney's clients, the public, or the courts, but this list is not exclusive. The first condition is that the out-of-state attorney associates a local attorney who actively participates in the matter. Second, the matter is related to a pending or anticipated court proceeding, and the attorney reasonably expects to be, or is, authorized to appear in that proceeding. Most courts have rules permitting an out-of-state attorney to seek permission to appear pro hoc vice. Some states require the attorney to associate with local counsel to do so. This rule anticipates that the attorney will comply with the applicable court rules. Third, the matter is related to a pending or anticipated arbitration, mediation, or other ADR proceeding where the services of the lawyer are reasonably related to the lawyer's practice in a jurisdiction where she is admitted. Fourth, in any other case where the attorney's services in our jurisdiction arise out of or are reasonably related to her practice where she is admitted. Comment 14 discusses the situations in which legal services in our jurisdiction might arise out of or be reasonably related to the out-of-state lawyer's practice in her home state. For example, the client may be located in the lawyer's home state. Or the matter, involving various jurisdictions, may have significant connection with the attorney's home state. Or the client's activities might involve various states where the corporate lawyer is helping the client assess where to locate by reviewing the laws of those many states. Or the lawyer may have expertise in a body of federal, nationally uniform, foreign, or international law, and so forth. Rule 5.5d1 provides that an out-of-state attorney may practice in our jurisdiction for her employer when pro hoc vice admission is not required. This paragraph applies to in-house counsel or government lawyers who are hired to provide all their services to the corporate entity or its affiliates. In some states, such an in-house attorney licensed in another jurisdiction is required to register with the local bar. Finally, Rule 5.5d2 permits an out-of-state attorney to provide legal services in our jurisdiction when she is authorized by federal or other law to do so. While these fairly recent amendments to Rule 5.5 were thought to address the realities of law practice in a national and international environment, they do not approach the liberal standards in the EU. European lawyers may practice in almost all commercial fields in any member country of the European Union. Rule 5.6, Restrictions on Right to Practice. This rule prohibits an attorney from making any agreement that restricts the right of a lawyer to practice after termination of the relationship. Thus, there can be no non-compete clauses in employment contracts for attorneys. The only exception is an agreement concerning benefits to the attorney upon his retirement. The rule also prohibits any restriction on an attorney's right to practice as part of the settlement of a client controversy. Thus, the opposing party cannot, as part of a settlement, prohibit the attorney from representing other clients against the party in similar lawsuits. The rationale for these provisions is not only that the lawyer should have professional autonomy, but more importantly, the clients should have the freedom to choose whatever attorney they want. Rule 5.7, Responsibilities regarding law-related services. Recall that attorneys are prohibited from entering into partnerships with non-lawyers where any aspect of the partnership will involve the practice of law. Thus, attorneys cannot participate in multidisciplinary practices, at least not for a profit. A lawyer and a financial planner cannot establish a firm, nor can a lawyer and a real estate agent, nor a lawyer and a family therapist. What can happen is that lawyers can employ the other professionals, or lawyers can own firms that provide law-related services. Rule 5.7b defines law-related services as those reasonably performed in conjunction with or related to legal services. Examples of law-related services are included in Comment 9: title insurance, financial planning, accounting, trust services, real estate counseling, legislative lobbying, economic analysis, social work, psychological counseling, tax preparation, and patent, medical, or environmental consulting. Rule 5.7 provides that a lawyer is subject to the rules of professional conduct with respect to law-related services that the lawyer provides as part of his practice. What this means is that all of the rules, confidentiality, conflicts of interest, business relationships with clients, etc., apply to the relationship with the client receiving the law-related service. Likewise, the rules apply with respect to law-related services provided by an entity controlled by the lawyer alone or with other providers if the lawyer fails to take reasonable measures to assure that a person getting these services knows that they are not legal services and the protections of the lawyer-client relationship do not exist. Accordingly, if the law firm wants to provide financial planning services as part of the firm, the attorney and accountant must be held to the standards of the rules of professional conduct. If the attorney and his financial planning partner want to set up a separate entity that does only financial planning and refer clients to that entity, they may do so. However, the burden is on the attorney to ensure that the client understands that these services are not legal services and the protections of the attorney-client relationship, confidentiality, privilege, etc., do not apply. Comment 5 states that when the lawyer refers his client to a separate entity that he controls individually or with others, the lawyer must comply with Rule 1.8a regarding business relationships with clients. Comment 5 states that when the lawyer refers his client to a separate entity that he controls individually or with others, the lawyer must comply with Rule 1.8a regarding business relations with clients. This concludes this unit.